Hey there, how you doing? Now, you have to forgive me for looking a little bit scruffy. This is like Sunday even. What is it now? It's the 8th of December. I've just been out fighting a gale, fighting a big storm there, trying to find out where my shed doors went so that I could go and fix them back on, which I have just done. So a little bit rough and a wind and everything like that, but it's all sorted now and back to safely having the doors on the shed. But I was just doing some emails and checking some stuff with people. And there was one of them that like disturbed me like quite a lot, which is from a young woman who's actually got a notice from her employer, thinking it's just coming up to Christmas time and everyone's trying to get presents and stuff like that, and it's for the council tax, and they've actually sent a notice or a letter to the employer to put on an attachment of earnings to her, right, coming up to like this time of year. And this is the whole thing. This is the setup, right? They do not have a legally executed liability order. Therefore, there is no legitimate interest for anyone to be handling her data. I'm attacking this mostly on a GDPR basis. This is how we can actually look at things a lot differently. If you use a GDPR it correctly, study it correctly. Now, I know some people say we're not allowed to look at it and it only belongs to them, but to hell with them. We know that we can actually study and research GDPR and all the legislation tied to it, and we can use it to our advantage when we're fighting these corporations that they're absolutely disgusting. So there's a few different regulations that they are breaching completely, but all to do with not having a legally executed liability order. Now, it's not our fault that they try and cut corners and go around things and do not get a legally executed court order, right? We know that they need to have that because of like the case laws as well, right? Under when it was Leighton versus Bristow and Suter 2023, the Judge Harrison, where he stated that you must have a legally executed court order. Now, he's not saying liability order, but he says it has to be a court order. And they haven't got one because they cut corners, they skip around it, and they think that we're all stupid and they think that they can do what they want. And so what I've done is I've actually created a set of SARs ready to do for the employer who's breaching GDPR as well as acting like a complete scumbag, but also for the council, which are just doing their normal, like treating everybody like scum, right? Think that they're all better than everybody else and that they can be above the law and they don't have to follow regulations, but they do. So initially what you want to do is you want to, if this ever happens to you, get straight onto the employer immediately, and you have got all of the laws backing you up, by the way. So don't be worried about them, right? If your employer is going to do something like that to you, it shows you what disrespect they've got for you anyway. So go straight for the jugular. So the first thing you're going to do, the first notice, I'm going to share it on the screen and we'll go through it and explain it bit by bit. All right, so this is the one. It's the notice to the employer. Obviously, you're going to put your name and address on the top, their name and address onto there. It starts off, subject, formal notice, unlawful wage deductions for alleged council tax arrears. Dear, whatever the employer's name is. I write formally to put you on notice that any deductions from my wages relating to alleged council tax arrears claimed by whoever that council could be are unlawful unless and until the council provides clear and lawful evidence of their entitlement to enforce such deductions. Legal framework governing wage deductions. The requirement for a legally executed liability order. In Leighton versus Bristow and Suter 2023, the High Court reaffirmed that enforcement actions, including wage deductions, cannot proceed without a valid, properly executed liability order issued by a magistrate's court. Such an order must be properly executed, bearing the court's official seal and the signature of an authorized officer, and clearly specify the liability in question. Without a valid liability order meeting statutory requirements, any attempts to enforce the alleged debt is rendered unlawful under Council Tax Administration and Enforcement Regulations 1992. 2. Employers' obligations regarding wage deductions. Under the Employment Rights Act 1996, Section 13, deductions from an employee's wages are only lawful if required by statute or made with the express consent of the employee. In this case, the statutory basis for the deductions hinges entirely upon the existence of a valid liability order, Without such an order, deductions are unlawful as established in Southfield versus British Telecommunications PLC 1998 IRLR 18. Employers must also act reasonably to verify the lawfulness of deductions, as stated in Cambridge and County Developments Contractors Limited versus Hughes 1973 Queen's Bench 522. An employer is under a duty to investigate the validity of any purported statutory authority before acting on it. They can't just go and do it willy-nilly. Employer liability for unlawful deductions and data breaches should, and then like the company name that you put in there again, proceed with deductions without verifying the existence of a legally executed liability order. The company may be liable for unlawful deductions in breach of the Employment Rights Act 1996, compensation for distress and anxiety arising from financial hardship caused by such deductions as exemplified in Southfield versus British Telecommunications 1998, breaches of data protection laws if decisions are based on unlawfully processed or shared personal information in contravention of the UK GDPR and the Data Protection Act 2018. Further, if the council's request for an attachment of earnings order was made without a legally executed liability order, this raises additional concerns under the GDPR. Both the council and, let's put the company name in there again, could be liable for unlawful processing of my personal data in violation of Article 6(1)(c) of GDPR, which requires a lawful basis for data processing. Failure to protect my personal data under Article 32 of the GDPR, which mandates appropriate security measures to prevent unlawful processing. And third, breach of confidentiality if my personal data was acted upon or shared without sufficient verification of the legal basis for its use. These breaches expose the company to complaints to the ICO and legal claims for compensation for non-material damages such as anxiety and distress caused by the unlawful processing of my data. Criminal implications of unlawful deductions. Deducting wages without lawful authority may also amount to theft, contrary to the Theft Act 1968, as it involves dishonestly depriving me of my earnings without proper justification. Action required. To avoid legal liability, I respectfully demand that, you put your company name in there again, suspend all deductions, cease all wage deductions relating to the council tax arrears until, put the council tax name in there, whoops, provide a valid and legally executed liability order bearing the official seal of the magistrate's court and the signature of an authorised officer on court-headed paper. Verify compliance. Confirm with, put the council in, that they have fulfilled the legal requirements under Council Tax Administration and Enforcement Regulations 1992 and provide me with written proof of such compliance. Further, please pause further action. Refrain from any further deductions or actions until this matter is resolved through lawful means. Consequences of non-compliance. Failure to comply with this notice will result in the following actions. I will file a formal complaint with the Employment Tribunal under the Employment Rights Act 1996 for unlawful wage deductions. I will pursue a civil claim for damages, including compensation for anxiety, financial harm, and unlawful data processing under the UK GDPR. I will refer the matter to relevant regulatory authorities, including the ICO and HMRC, if there is evidence of systematic non-compliance with statutory deduction requirements. Confirmation of receipt. Please confirm receipt of this letter and provide detailed response outlining your intended course of action within 3 days of the date above. Failure to comply with this notice will leave me no option but to take immediate legal action to protect my rights. Yours faithfully, and put your name in there. I'll stop sharing. So as you can see, right, I've outlined there all of the actual implications, especially the ones there that are going on the GDPR, where they are breaching it or could be breaching it. And we know that they do not correctly get a legally executed liability order. You cannot have a letter from the council, as we've seen in Leighton versus Bristow and Souter. The letter from the council saying, oh yeah, they owe us money, is not good enough to prove a legal liability. So if they haven't got the legally executed liability order, then they should not be writing to the employer, and the employer should not be trying to take anything from you. I'm going to upload that. I'm going to attach it onto this video, okay? So you can actually download that and use it for yourself. It's all there just for you. Now, what we need to do is we need to have a follow-up to this as well, just in case. I'm also going to show you what to send to the debt collectors for this as well. But I'm going to show you, first of all, the next step for the employment, and then we can do it like in a proper logical manner. So I'll share my screen again. So this is the follow-up notice, or SAR, to the actual employer. So obviously name and address the same. Subject, follow-up, subject, access request, non-compliance notification, because we're presuming that they haven't actually followed through with compliance, okay? To the data protection officer in that employer's name, I'm writing to follow up on my subject access request dated, let's put that in red there as well, submitted under Article 15 of the UK General Data Protection Regulations and Section 45 of the Data Protection Act 2018. As of today, you have failed to respond to my request within the statutory time frame of 1 calendar month, as required under Article 12(3) of the GDPR. This lack of compliance is unacceptable and constitutes a clear breach of your obligations under data protection law. For clarity, my original SCR requested information relating to the council tax enforcement action and attachment of earnings, specifically a copy of the liability order or related court documents provided by, and put the council in there, as the basis for the AOE request. All correspondence and documentation received from the council, internal communications, notes or decisions made by the company in relation to this matter, records of any information about me shared with the council or third parties regarding the AOE, documentation supporting the lawful basis under Article 6(1) of the GDPR for processing my personal data, copies of internal policies or procedures followed by your company's name when implementing AOEs or responding to third-party requests for wage deductions. Additional time frame to comply. I'm granting you an additional 7 days from the date of this letter to provide the requested information in full. Consequences of continued non-compliance. Should you fail to comply with this follow-up request, I have no alternative but to 1, file a formal complaint with the Information Commissioner's Office regarding your breach of GDPR, initiate legal proceedings to enforce my data protection rights under the GDPR, and seek compensation for the inconvenience, distress, and anxiety caused by your non-compliance. Next steps, please confirm receipt of this letter and ensure full compliance with my SCR within 7 days. If you require any clarification about this request, you must contact me promptly. Okay, so we'll stop sharing there again. So you can see again on the follow-up there, now we're just presuming that they haven't complied. They may well have done, right? And then you wouldn't need to do any other notices, so it's all fine. But we're getting ready there just in case you have to, okay? So we've got the second one. Let's just presume that they haven't complied and you need to take that step further. So now we've created that, showing you again the sections there are under GDPR where you are allowed to actually protect yourself and actually fight for your rights. That's what it's all about. And I'll come across a few people now after dealing with this first one that are getting these attachment of earnings for these. They're just simply not liability orders. They haven't executed it legally. You cannot have a letter just from the council saying, oh yeah, you owe a debt, and then your employer goes, boom, yeah, I must do what I'm told. Yeah, only if you're following the actual statute. They're all in a public body. They're all their limited companies and everything, so they have to follow the statutes. However, it's got to be ready and it's got to be legally complied with. So this is how you actually file it. This is what you do. You've sent your first one off. You've told them what the situation is. If they haven't complied within that 1 calendar month, then you have to actually send the second one off. And if they've deducted your wages, then your compensation is going to go up anyway, isn't it? Again, what we'll have to do is be ready for them not to comply. If they do comply, even after the second one, then great, you're going to get all your money back, everything's going to be fine. But if they're not going to, then you need to get the next SCR, which is what we call your letter before action, because this is really going to put them in line saying, if you do not do this within, boom, say 3 days, then we are going to file a court for compensation, anxiety, distress, inconvenience, hardship, and all of that. Okay, so what we'll do is we're going to share the screen again, and we'll go through the letter before action, and then that's the third in the series. Then we're going to go and have a look at the ones that you're going to send to the actual council when they're actually doing this and sending out, which is breaching your data. They shouldn't be sending information out about you to anybody. So here is the third notice, obviously name and address all the same before. The subject now is letter before action, unlawful wage deductions and data processing. To the data protection officer, employer's name, I write further to my previous correspondence, including my subject access request, SAR dated, and you put the date in there, and my follow-up letter dated, and you put that date in there. Despite my request, you have failed to provide evidence of a valid and legally executed liability order from the Magistrates' Court authorising the attachment of earnings implemented against my wages. Unlawful actions by, put the company in there. Unlawful wage deductions. Under the Employment Rights Act 1996, Section 13, deductions from an employee's wages are only lawful if required by statute or made with the employee's express consent. In this case, the statutory basis for deductions hinges entirely on the existence of a valid liability order issued by the Magistrates' Court. The absence of such an order renders your deductions unlawful. This is supported by Leighton v. Bristow and Sutter 2023, where the High Court emphasised that enforcement actions, including wage deductions, cannot proceed without a properly executed liability order. Your failure to verify the lawfulness of the Council's request implementing deductions constitutes a breach of the Employment Rights Act 1996 and exposes your company's name again in there, whoever you're working for, to liability for financial and emotional harm caused by your actions. Unlawful processing of personal data. By acting on the Council's AOE request without verifying the existence of a valid liability order, you have unlawfully processed my personal data in breach of the UK GDPR and Data Protection Act 2018. Specifically, Article 61C requires that data processing must be based on a lawful obligation. No such obligation exists in the absence of a valid liability order. Article 5(1)(d) mandates accuracy in data processing. Acting on inaccurate or incomplete information, unverified claims by the Council constitutes a breach. Your actions have caused significant distress and inconvenience, compounding the financial and emotional harm resulting from the unlawful deductions. Failure to comply with SAR obligations. Your failure to respond adequately to my subject access request further breaches your obligations under Article 15 of the GDPR and Section 45 of the Data Protection Act 2018. This non-compliance obstructs my ability to verify the lawfulness of your actions and escalates the harm caused. Legal remedies sought. In light of the above, I am entitled to pursue the following remedies: reimbursement of unlawfully deducted wages, immediate repayment of all sums deducted from my wages under the alleged AOE, together with interest, compensation for distress and financial harm, damages for the anxiety, inconvenience, and financial hardship caused by your unlawful actions, data protection breach compensation, compensation for the unlawful processing of my personal data as permitted under Article 82 of the GDPR. Next steps. To avoid legal proceedings, I demand that you cease all deductions, suspend any further deductions from my wages relating to this matter. 2. Provide full reimbursement, repay all sums deducted to date along with interest at the statutory rate. Provide the requested information, disclose all data and documents relied upon to implement the AOE, including evidence of a valid liability order if one exists. You must respond to this letter within, I would actually put that down, 3 days. 3 days of receipt. Failure to comply will leave me with no choice but to initiate legal action without further notice, including filing a claim in the Employment Tribunal under the Employment Rights Act 1996 for unlawful wage deductions, issuing proceedings in the County Court for compensation under the GDPR and Data Protection Act 2018, reporting the matter to the Information Commissioner's Office for regulatory action regarding the data protection breaches. Conclusion: this letter constitutes a formal letter before action in accordance with the pre-action protocols. I urge you to take this matter seriously and act promptly to resolve it. Yours faithfully. Okay, so there you have it. So if you have received one of these attachment of earnings, you need to challenge it straight away. This is your rights. You are so protected under GDPR and employment rights as well. They can't just unlawfully deduct wages no matter what the council say. The council have got a job to do. Granted, they've got to do it correctly and legally. So if they want a liability order against you, then they should make sure that they do it correctly when they're going to get a proper court order from a real court and get signatures from real magistrates and the seals of making it a legally executed court order. All right, we've got the case law to actually prove that the judges state point blank, if there's no court order, you have no authority to enforce. There is no action you can take. That's to any debt collector, which in this case, the employer is acting like a debt collector. We'll attach all of those, the SCR or the notice 1, 2, and 3, or the SCR they are, to the employers. But now we're going to go back and have a look at the SCRs that we will send to the actual council who started this action in the first place, which is still breaching GDPR because we know they do not have that legally executed court order. I'll share the screen again to show you the SCR to the council. So this starts obviously the same. You've got the name and address to the council, council address. Subject access request, legally executed liability order and related information. To the data protection officer, I'm writing to formally submit a subject access request under Article 15 of the UK General Data Protection Regulations and Section 45 of the Data Protection Act 2018. This request pertains specifically to alleged council tax arrears and enforcement actions taken against me, including attempts to impose an attachment of earnings order. In light of the Leighton versus Bristol and Suter 2023, where the High Court reaffirmed that enforcement action cannot proceed without a properly executed liability order issued by the Magistrates Court, I require access to the following information: the legally executed liability order, a copy of the liability order purportedly issued by the Magistrates Court in relation to my alleged council tax arrears. This order must bear the official seal of the Magistrates Court and the signature of an authorised officer on court-headed paper. Evidence of compliance with the Council Tax Administration and Enforcement Regulations 1992. Records confirming the date and methods of service of the liability order upon me. Details of any court proceedings related to the issuance of the liability order, including case references and hearing dates. Number 3, internal records and communications, all correspondence, meeting notes, and internal decision-making records related to the alleged arrears and the decision to pursue an attachment of the earnings order against me. 4, data sharing with my employer. Details of any communications or information shared with my employer regarding the alleged council tax arrears, including copies of all correspondence or notice sent to them. Evidence of lawful basis for processing my data. Documentation supporting the lawful basis under Article 6.1 of the GDPR for processing and sharing my personal data in this matter. Response timeline under Article 12.3 of GDPR. You are required to respond to this request within 1 calendar month of receipt. Failure to comply with this request will constitute a breach of GDPR and may result in a formal complaint to the ICO and legal action to enforce my rights. Please confirm, blah, blah, blah. So the thing is, forget about the actual, if you've got, I'm not saying you should be fighting council tax, paying it or not paying it. You do ever what you want, all right? A lot of people are suffering and just simply cannot afford to pay it right now. Whatever the reasons is that you've got into this situation, it's none of my business, right? But I'm just showing you that people need to act legally, right? If you want to be public and in the legal world, right, well, they need to actually act legally. So the councils, if they're going to go and do this liability order stuff, then they have to do it correctly. But we know that they're not. I've been involved in this, like not mine, but I'm going there with people to these fake courts and seeing what goes on, and it's ridiculous. So we have to ensure we hold them to account. That this way, when they are breaching, and they are breaching massively GDPR regulations, right? Don't worry about like, oh, I'm going to, you know, like not my, I want to challenge my obligation to pay, and I'm not challenging all that rubbish, right? Look, just use the power of GDPR and make sure that you can hold them to account because they breached your data ignorantly, because they are ignorant in their attitude, but they absolutely are not ignorant that they know that they are breaching the data. There's more than one way to skin a cat, as they say. So why not use the tools that they have created that you can use against them? GDPR is so powerful. They breach the data all the time, not just like debt companies now, but these councils, employers will ignorantly try and follow the rules that they've been think that they're like following rules, and they're not. They're actually breaching them all. So hold them all to account under GDPR. It's a powerful tool, rather than getting angry and say, well, my obligation. Look, use the tools provided, and I'm showing you how to actually do it, that you can go out and you can start getting the better of these councils and anybody that steps on your toes, like your employer and the debt collectors. We'll get onto that a bit later, right? This is only about the attachment of earnings where the employer's acting as a debt collector. Let's have a look at the follow-up SAR to the council if they don't actually comply with the first one. Okay, so we're just presuming that the council have not responded to the first SAR. Now, come on now. It would be really unlike a council to ignore what you're asking for, wouldn't it? Yeah, right. Okay, they think they're above everything. They actually think that we are just low life and they can treat us any way that they want. So let's start off, obviously, name and address, council name, blah, blah, blah. Follow-up, subject access request, non-compliance, notification to the data protection officer. And by the way, just stick with the data protection officer. You don't need to start trying to do this free man on the land stuff where you're going to be going, I want to write to the SEO, the CEO, I should say, of like the council. Forget it, right? They're never going to see it anyway. It makes no difference. The data protection officer is what you're just going to address it to. And if it gets through to court action, what you're going to have to do, the person, as in the corporation, the dead entity that you're going to have to file the N1 against for the court action is going to be the council, not the name of the CEO of the council or the mayor or whoever it would be. Honestly, let's just stick to the facts and stick there using the legal processes of GDPR, okay? Please. Right, I'm writing to follow up on my subject access request dated, and we'll put the date in there. Submitted under Article 15 of the UK General Data Protection Regulations and Section 45 of the Data Protection Act 2018. As of today, you've failed to respond to my request within the statutory timeframe of 1 calendar month, as required under Article 12.3 of the GDPR. This non-compliance is unacceptable and constitutes a serious breach of your obligations under data protection law. I reiterate my original request and demand the immediate disclosure of the following. The legally executed liability order issued against me, bearing the court's official seal and the signature of an authorised officer. Records confirming compliance with the Council Tax Administration and Enforcement Regulations 1992, including the service details and the court proceedings. All correspondence and internal records related to the alleged arrears, details of any communications with my employers regarding the alleged arrears, evidence supporting your lawful basis for processing and sharing my personal data. I grant you a further 7 days from the date of this letter to comply with my request. Failure to do so will leave me with no option but to escalate this matter through a formal complaint to the ICO and legal proceedings to enforce my rights. Yours. So that is the follow-up, presuming that they have ignored it, which they seem to really enjoy doing, don't they? Just ignoring your notices. But remember, we are doing this 100% legally under GDPR regulations, nothing else. We're not trying to ask them where's our obligation. We're not trying to challenge them. We're just talking about what their legal duty is and what the GDPR is. So that's it. Right, let's stop sharing. So you send the first SCR off to the council, right? If they haven't responded, then you're going to send that second one. We are sticking to GDPR. We are being 100% using their rules, which is statutory legislation rules. That's what I mean by their rules, right? So we're not going off on like, oh, I'm going to be a man or a woman and I'm standing under law and common law, right? What we're doing is we're using GDPR and Data Protection Act. We are using acts and statutes that have been created by these corporate bodies to fight the corporate bodies. We're using their rules against them. so they can't complain. So all we're doing is exactly what we're allowed to do under the legal requirements, and then putting them in a position where they have to prove that they are being legal in their actions, which we know through experience that they are not. So we can hold them to account. Now, you can actually file these N1 proceedings against these entities, be it your employer, the first one, who are acting as a debt collection agency. If they have breached your GDPR, that's a claim of 5,000 minimum, plus of all the compensation you can add on top of that, about like loss of wages, hardship, and the rest of it. And then you can do this also with the council. So if they're breaching your data because they have not got a legitimate interest, that's what it's called. So they have not got a legitimate interest to be processing your data and sending it to your employer. Oh, look, you know, these people haven't paid their dues. That's what they're doing. They're calling you a bum, right? So what you're going to do is you're going to put in show them, go through the SAR, first one, then the second I've just showed you. I'm going to show you the next one now, the letter before action. You have to do it that way because that's the pre-action protocols. We have to stick again using the court rules. And once you've shown that you've used the court rules to line them up there, you can't just go and file an M1. You have to give them a chance to rectify the situation. Once you've given them chances to rectify the situation and they continue to be acting illegally, then we can file for compensation at the court. And this is how you're going to do it. So let's see that letter before action. I'll share my screen again. So in the letter before action, obviously name and address all the same again. So letter before action, breach of data protection rights. To the data protection officer, we're being legal here. We're not being silly. I write to formally notify you of my intent to initiate legal proceedings due to your failure to comply with my subject access request submitted on whatever. Your refusal to provide the legally executed liability order and related information is unlawful and constitutes a clear breach of the UK General Data Protection Regulations and Data Protection Act 2018. Breach of statutory obligations. Failure to disclose a liability order. The absence of a legally executed liability order undermines your authority to enforce any alleged arrears as confirmed in Leighton versus Bristow and Suter 2023. Non-compliance with Article 15 of the GDPR, your refusal to provide access to my personal data, including a liability order and related correspondence, violates my rights under Article 15 of the GDPR. Remedy sought. To resolve this matter without court intervention, I demand immediate disclosure of the legally executed liability order and all other data requested in my SAR. Confirmation that all enforcement actions, including communications with my employer, have been paused until this matter is resolved. Next steps. Should you fail to comply within 7 days, I will file a formal complaint with the ICO. 2. Initiate legal proceedings to enforce my rights under the GDPR and seek compensation for the distress caused by your unlawful actions. This letter serves as your final opportunity to resolve the matter amicably. So why are we using GDPR and why are we asking for the legally executed liability order? It's very similar to why, when we're dealing with debt, that we ask for the legally executed deed of assignment, because they don't have it. They're cutting corners to make more money. So it's all about increasing their profits and minimizing your enjoyment of life. All right. So what they've done is they've created a liability order in their own head, so that they don't get a legally executed one doing the court proceedings correctly. They don't do due process. They don't have everybody lined up. They do about 1,000, 2,000 of these liability orders at a time. So if they can't have due process, they can't have a hearing. There's been no consideration went into should it actually have a liability order or not. They just go stamp, 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 right? But it's just them stamping it. It's not a court seal. There's no official paperwork. When they send you something, they send you a notice of a liability order, not the liability order, because that doesn't exist. So because they send you the notice of the liability order, we're requesting the legally executed court order. We know that doesn't exist. So therefore, they're breaching GDPR because they can't supply what they've alleged they have. Right? That's the angle that we're going at. We're going after their Achilles heel. So we're using their rules, right? GDPR, it's their rules. We didn't invent them, right? All we've done is study them, find out what we can use against them, and we're protecting our rights as we're written to protect the rights. So what we're doing is that's why we use it against the liability order. You can use it because if there is no liability order, I tried to chop my finger off before, that's why I've got that on. If there is no liability order, then there is no legitimate interest for either the employer, the attachment of earnings, or for the actual council to be supplying any data to anybody else, including the debt collector or your employer or anyone else. That is the breach of data. That is what can be used against them. So there, right, what you can do, once you've actually done that, you can then file the N1. We actually did a webinar a couple of weeks back where we showed everyone how to actually go and do the filing of the N1, how to make sure it's legally executed, the way you put it in, and how to do it so it looks like a barrister has actually done it for you. Obviously, I mean, we have got recordings of that. I will put it up. You can get access to that. I'll arrange that. We will maybe do another one, which is just specifically how to do it for an employer, as we've just done and shown you the SARs, and also how to do it for the council. Because that other one, I think although it did show a little bit the council, it was mainly about on the actual debt collectors, or for unsecured debt, credit cards, bank loans, that type of thing. But we did touch a little bit on council tax, but obviously it would be better showing you on this one a follow-up version where you can maybe see how to do an N1 to file for the court for the employer messing you around and deducting wages and ruining your life, right? And also like the council as well. But I will upload and I'll attach it onto this video so you can see all of those documents there, and they're yours to use for free. All right. So have a good one, and we'll see you next time.